All right, please.
How long have you held that position?
I've been a detective for the last 7 years.
Have you held other positions then within the Fremont County Sheriff's Office?
I have. I've worked in the jail, worked on patrol, and as a resource officer.
Do you have any specialized training in order to be a law enforcement officer?
I do. I graduated from the Post Academy and I earned my basic, intermediate, advanced, and master's certificates.
Were you working in Fremont County on October 19th of 2019?
I was.
Were you on shift that day?
No, I was not.
Did you end up receiving a call from someone about an unattended death?
I did.
Who called you?
That was Deputy Allie Greenhall.
Do you know why she ended up reaching out to you?
She reached out to me because she could not get a hold of the on-call detective at the moment.
And when we talk about an unattended death, can you explain to the jury what that is for purposes of law enforcement?
Yeah. A unattended death is any death, whether it's natural, self-inflicted, or otherwise accidental, that is gone on other than one that's not being attended to by a physician.
So if a physician is not present when someone passes away, you may respond out to an unattended death.
That is correct.
At the time in Fremont County, as a detective, did you respond out every time there was an unattended death?
No,
When would you respond out as a detective?
depending on age, circumstances, possible signs of reasons for death, any obvious wounds or anything that might throw a flag up to whoever was on shift or taking the call.
And when you talk about whoever was on shift or taking the call, what position would that individual hold within the sheriff's office?
That would be a patrolman.
And was Deputy Greenalch a patrol officer at the time?
Yes, he was.
When she reached out to you, did you end up speaking with her on October 19th?
I did.
Did you learn who the decedent was?
Yes.
And who was that?
Tamara or Tammy Daybell.
Had you ever heard that name before?
If I had, I couldn't recall at that time.
Had you ever heard the name Chad Daybell at that point in time?
No, no, I had not.
When you received the call, did you end up asking questions of the deputy?
I did.
Do you recall what some of the inquiries you made were?
Wanted to know uh, what she was seeing, and she described the scene to me and the state of Tammy and what it looked like, along with who found her and who else was on scene.
At that time, did Deputy Greenalch report anything suspicious to you?
Nothing was reported. No,
Did you provide any direction to Deputy Greenalch as far as what she should do?
I did. I requested of her to take a lot of photos, and my exact wording was to have her take a shit ton of photos.
Did you request she do anything else that you recall?
To talk with the coroner when she got on scene and discuss whether or not to do autopsy or retrieve blood. Mm.
And from your understanding, who makes the determination as to whether or not to have an autopsy performed?
Final decision comes down to the coroner.
So that is not a decision ultimately up to law enforcement.
No, it is not.
When you spoke with Deputy Greenalch, did she mention to you anything about pink foam or blood sputum coming from Miss Daybell's mouth?
No, she did not.
How many unattended deaths have you responded out to approximately?
Probably 80 or more.
And back in 2019, would that number have been a little less?
Yes,
Out of those unattended deaths, have you ever responded out to one where you saw the foam or the sputum?
Judge, I'm going to object to relevance.
Overruled.
I had not.
If you were told that, would that have impacted your decision on not responding out?
Yes,
And would you have responded out?
I would have.
Did you do anything else after you received that call from Deputy Greenalch?
I did.
And what did you do?
I called Lieutenant Joe Powell and gave him a update on the call Ally was on, knowing he was a lot closer than I was. And if somebody was going to be responding, he would be the most likely or the quickest one to get there.
And did you share with him the details that you had learned from Deputy Greenalch?
I had.
And, and again, based on the information you were provided from the deputy, a decision was made not to respond out.
Correct.
But it sounds like since then you'd learned additional information regarding the scene. Is that fair?
Yes,
Such as the pink foam.
correct.
Do you know who the on-call detective was that night?
I do.
And who was that?
That was Detective Vincent Kayakamanu.
At some point, did you learn whether or not Deputy Greenalch also was able to get in touch with him?
She was able to, yes.
So initially, is it fair to say that on October 19th of 2019, outside of the initial response from the deputy, there was not an investigation launched into Tammy's death?
Correct.
At some point in time, did you become involved in an investigation into Tammy Daybell's death?
I did.
Do you recall approximately when that would have been?
For myself, I started about mid-December of 2019.
Do you know when Fremont County Sheriff's Office became involved?
Right at the end of October or the very first of November
And that would be of 2019.
2019.
At the time you became involved in the investigation into Tammy's death, were you aware of any other related investigations that were ongoing?
I was.
What were those investigations?
So there were quite a few agencies involved for some different reasons. Uh, Rexburg Police Department and the FBI were looking for JJ Vallow and Tylee Ryan. In Gilbert, Arizona, they were investigating the attempted shooting of Brandon Boudreaux. And in Chandler, they were doing an investigation into the shooting of Charles Vallow.
And we talked about on October 19th, you had never heard of Tammy or Chad Daybell that you could recall. Is that correct?
That is correct.
Had you ever heard the name back on October 19th? Had you heard of JJ Vallow?
No,
Had you heard of Tylee Ryan?
no,
Had you heard of Lori Vallow?
no,
Alex Cox?
none,
Had you heard of Charles Vallow?
no.
So you learned of these individuals later when you became involved in the investigation. Is that fair?
That would be correct.
And would it be fair to say that it was a joint investigation?
It was, yes.
Was your focus in regards to the investigation on the death of Tammy Daybell?
It was.
Were there specific areas of the investigation that you personally focused on?
Correct. Yes, there were.
And specifically, did you look into Tammy's health?
I did.
What were some of the things you looked at in relation to Tammy's health?
So one of the things we looked at in the beginning was medical records that we were able to acquire through Seasons Medical and Teton Medical and Walmart Pharmacy.
And in talking about those medical records, you listed 3 different places. Do you know why the records were obtained from Teton and Seasons?
Those were the places that we could find that she had been to when we did our background on the prescription monitoring program through Idaho. It showed she had some prescriptions from those medical facilities. So we were able to get the records from those.
And are you personally the one that received those records?
No, I was not.
At some point, did you review those medical records?
I did.
And we talked about how you located those. And actually, I'm going to withdraw that and back up. When you reviewed those medical records, was there any indication to you in your review of health issues related to Tammy Daybell?
There were just some general health issues. She had been prescribed tramadol for some wrist pain. And then she was also prescribed fluoxetine for managing depression.
At some point, as part of your investigation, did you review statements that had been provided by Chad Daybell to law enforcement and the coroner?
I had, yes.
And were those the statements that were provided on October 19th of 2019?
Yes, they were.
When you looked at those statements, do you recall some of the things Chad had indicated in relation to Tammy's health?
Yes.
What were some of those things?
Some of them were reported as being dizzy, I believe fainting, slowing down during classes.
When you looked at the medical records, did you see any indication or reference to Tammy having any dizziness or dizziness spells?
No, I did not.
Did you see any indication of seizure or seizure-like activity being reported that would reference or explain a slowdown in activity?
I did not.
When you looked at those statements from Chad, did you actually review the reports from the deputy on scene?
I did.
And did you learn Who else was on scene or there when the initial deputy arrived?
Yes.
And who else was in the residence?
Garth Daybell.
In those reports, did you ever see Garth, any indication from Garth that he had concerns about his mother's health?
No,
Did you ever see any indication from Chad regarding Tammy having a prior history of anemia?
no,
Did you ever see any indication that Chad had reported he was concerned because of a history of heart conditions in Tammy's family?
none.
In reviewing those reports, did you see any statements made by Emma Daybell at the time of her mother's passing?
Yes, I believe her statement was that she said her mom had been slowing down in one of the fitness classes.
Did you ever get to talk to Emma Daybell?
No, I did not.
Did you make attempts?
Yes,
And she was unwilling to speak with you?
that is correct.
When we talk about the medical records and how you located those, did Chad Daybell ever tell you about any other medical providers? Or did you learn if he told anyone about any other medical providers in law enforcement?
No, there is no other mentions.
Did anyone in his family, any of his children ever provide you information regarding other medical providers to look at?
No, they did not.
Through your investigation, did you learn whether or not Tammy Daybell had some life insurance policies?
Yeah, I did.
What did you learn in regards to that?
I learned that she had two life insurance policies. One was through Primerica and the other one was through LifeMap.
And in relation to those insurance policies, through the investigation, are you aware if some documents were obtained from specifically looking at LifeMap?
Yes,
Did you review those responsive documents from LifeMap?
I did.
Do you recall reviewing a form titled Beneficiary Statement?
Yes,
And Your Honor, by stipulation, I believe LifeMap has already been admitted, but I have what's been marked as States Exhibit 152, which is the beneficiary form just referenced, or the beneficiary statement.
And are you referring to both the beneficiary statement and the admitted exhibit?
This is just the beneficiary statement that's been marked as 152.
Okay, and that would be a new unadmitted exhibit at this time?
Correct.
Okay,
It's just part of a stipulated to exhibit, but only one part of it, so it's been marked separately.
all right. And are you moving to admit that at this time?
I would be moving for admission.
Any objection to exhibit 152 being admitted?
No, Your Honor.
Okay, exhibit 152 is admitted.
And Your Honor, if I can, I have a courtesy copy for the court and then the actual exhibit. If I can have the exhibit handed to the witness.
Thank you. Yes.
And if you look at that, Detective Mattingly, is that a accurate copy of the beneficiary statement you reviewed?
yes,
And Your Honor, I am going to ask to publish this. I'd be publishing off the Elmo.
Okay. You're permitted to do that.
Do you want the exhibit published? I have a copy, but would you like the actual exhibit published?
Yes, please.
And Detective, I think there may be a laser pointer up there. If that's beneficial as we look at this.
Could you pull that down for a second and we'll have a quick sidebar? redacted the personal identifier information off of that before publishing. So you can continue, Ms. Blake. Thank you.
Thank you, Your Honor. And Detective, you indicated you. And actually, I'm going to move it up. At the bottom of the form, can you see who signed this? Or not at the very bottom, but can you see who filled this out?
Chad Daybell.
And actually also, do you see the date that he signed this?
It'll be 10/30/2019.
And again, Tammy was pronounced dead on October 19th of 2019, is that correct?
Yes.
And then if we go back to the top.
Judge,
Yes.
I don't know what's going on, but I'm seeing motion in the jury pool.
Is your monitor not working? Oh, we got a monitor not working. Thanks for,
Looks like
somebody's-
maybe none of them are.
okay. See if we can get that sorted out. Thank you. I think that might have got, still no? Hmm. We're gonna have a tech issue with that. I don't think we can resolve that quickly. For now, I'm gonna suggest we keep moving where the jurors can still see that up there, and I'll note. Also, you will be provided this exhibit for your deliberations if you need to reference it back.
Detective Mattingly, when we look at this form, we've already indicated it was filled out by Chad Daybell, correct?
Correct.
And on there, there's a designation about when the health of the deceased first became impaired. Do you see that under the medical information?
I do. That'll be on the left.
What was the date that Chad Daybell wrote in there?
October 18th, 2019.
So the day before Tammy died is when he indicated her health became impaired?
Yes.
And I guess let me back up there. The day before Tammy was declared deceased, he'd indicated her health had started to have changes.
Yes.
Can you also see the last date that she attended work?
I'll be on the right side. The date indicated that she last worked was on October 18th, 2019.
And then under there, there's a section attending physicians. Can you read into the record what Chad wrote under physician name?
Under the physician name, he wrote none. She died in her sleep.
So on this particular form, Chad Daybell didn't indicate that she was seeing any medical provider.
Correct.
Detective Mattingly, did anything on that beneficiary's form support the statements Chad Daybell previously gave to law enforcement?
No.
What else, if anything, did you do in relation to looking into Tammy's health?
I also got a search warrant from Fitbit.
And why did you end up requesting a search warrant from Fitbit?
As we were reviewing the crime scene photos, on a nightstand by Tammy's side of the bed was a Fitbit. And knowing information that could possibly be on Fitbit, we requested a search warrant.
Did you receive responsive documents from Fitbit?
We did.
And did you yourself review those?
I did.
And Your Honor, I have what's been marked as States Exhibit 108. It is an affidavit of records from the custodian from Fitbit. I believe this is also a stipulated to exhibit pursuant to that, but I do have that affidavit for the court and would move for its admission.
All right, Exhibit 108's been offered. Is there any objection?
Judge, it was a stipulated agreement to the parties that this information would be allowed.
All right, then without objection, Exhibit 108 is admitted.
And Detective Mattingly, in looking at that, have you seen that document before?
Yes, I have.
And you reviewed the responsive documents that that's referencing?
Yes.
Based on your review of those documents, was there quite a bit of information?
Yes, there was.
And backing up a little bit, what is it that made you get a search warrant to Fitbit or to request documents from them?
So Fitbit, in reviewing what they had to offer, we were looking for heart rate and sleep patterns and times that people are asleep, along with their activity. The reason we were looking for those is to hopefully narrow down the exact time of death or a closer period to do so.
And did you actually locate a Fitbit at the Daybell residence?
No, we did not.
How did you come to determine that Tammy Daybell may have worn a Fitbit?
So we found a picture of the Fitbit from the scene photos that Allie had taken. And then from there, we also looked into her Facebook account, which had several pictures where you could see her wearing a Fitbit.
And as part of your review of that Fitbit data, did you prepare an exhibit for today?
Yes,
Do you believe that that exhibit would aid in your testimony?
yes, it would.
Do you believe it would aid the jurors in understanding the evidence?
Absolutely.
Your Honor, I have what's been marked as States Exhibit 108A, and I would move for its admission.
Any objection?
No objection, Judge.
Exhibit 108A is admitted.
And similarly, Judge, this is actually going to be a jump drive, but I do have a print off as a courtesy.
Okay. Are you going to be publishing this, Ms. Blake?
Yes, Your Honor.
I think we might have tech available to come in here quickly and potentially get the jurors' monitors reconnected. Okay, they're on their way. Let's take a real quick, just stand up break and maybe the jurors can be excused to the hallway for a minute. And I'm hoping this will just be quick, but we'll see if we can get those monitors working again.
All right, please.
Yes, this will be. I've had fitness monitors off and on for 14 years, and it can tell a lot. I took a hike, and there was a tree in the middle of the path, and on the way up, I went around the right side of the tree because, you're kind of trained to go to the right as a traffic measure. And so when I came back down, I went to the right of the tree again, and you could see on the map where the tree was, because you could see where my path diverged, and there was a little tiny circle in the middle. So, and they've got all sorts of things like accelerometers and step counting. Did she really get up in the middle of the night and go throw up? It would show if she got up, took steps. I'm not sure about Fitbit. I think that it tracks sleep, so it would show if she woke up because of something like that. Some track heart rate. It's really interesting. Now, right now I've got a what do you call it? A ring, a smart ring, which tracks. It'll do blood pulse, I guess I should say, and it does oxygen, and it'll do steps. It's supposed to do fitness activities, and I liked the one that I had before, about 6 years ago, the best. I can't remember the name of it, but the company stopped doing it, and so my watch became obsolete. I was supposed to send it back to the company to get a $200 credit for it, but that was at the time of my house fire, and I kind of lost track of it. So that one was extremely good. No, it wasn't that. The first one I had was the Body Bug, and then can't remember the next one after that. And then I had a Fitbit Surge, and the wrist strap broke on it, and so I kind of got away from using it. And last month I got this ring, and so let's take a look at the data on my ring right now. Let's see. It shows that I got 4 hours and 15 minutes of deep sleep, 2 hours and 30 minutes of light sleep, for a total of 6 hours and 45 minutes of sleep. And it seems to calculate things in 6-minute or 15-minute intervals. It's saying that I woke up at 8:45. I didn't. I woke up at 5:02 when we started the stream, or the Okay, so let's take a look. Not at sleep, but heart rate. Okay. I'm doing a reading right now of the heart rate. It's saying it's 108 at the moment. 112 is the maximum. It'll go down in a second here. It's saying 108, 107, 106, 105, 103, 101, 100, 101. So these things could be really interesting, and I could see if Tammy had one, how Chad would get rid of it, because he'd be afraid of the data showing incidents at the time of murder and what her activity level was and so forth. Because let's see, this smart ring I've got do walking, running, cycling, hiking, and golf. And I haven't done much walking today, so it says I've only done 4/100ths of a mile, and that's probably not too far off. Let's see. Blood oxygen level. That would be something that if he smothered her, that would definitely show a drop in her heart rate. So let's see. It's taking its time on giving me the oxygen level. Seems like it usually averages around 99. I think it reads maybe a percentage or two higher than it should from when I went to the emergency room. Okay. 90, 98, 99, 97, 98, 99, 98. So pretty high. Yeah, I think you'd be afraid of do the rings come in different sizes? Yes, they come in full sizes. They don't come in half sizes. And the smallest this one came in, I got it off of Temu for $20. And the smallest size was an 8. I have seen some other versions which came as small as a 7. So, you have to choose a bigger finger. They are fun. They really are. When I went to the emergency room last week, when I was having severe pain with my shoulder, they had me walk over for x-rays, and could see how it was a long walk to x-ray, and I had like 7.79 miles on the steps for the time I was there at the hospital. So I have a bunch of things that I need to film. I've been doing some for my baby channel, which I haven't actually started yet. I need to get some videos up for that. And some of them are Temu reviews. I kind of have broken it down into household products, jewelry, craft supplies, stuff for my niece's wedding. And I have fun with it. What can I say? So this little break is longer than I would have expected. Sounds like something's not muted. Take a look. Aha, I found the guilty. So, let's see. Let's look at Fitbit and what it can do. Okay, here's one on Fitbit talking about health metrics. So, Fitbit does oxygen saturation, skin temperature, breathing rate, heart rate variability, the variation of time between heartbeats each night. Says a significant decrease may indicate your body is showing potential signs of stress, illness, or fatigue. So that would be really good for, was Tammy really having issues and so forth. Now, I've got a smartwatch monitor, which is supposed to do your blood pressure as well, but it doesn't play with iPhones. And so I need to find my old Android to get the software on that. Resting heart rate over each day and over the past week. Let's see. So that's some things. Let's see. Take another look at another article. Okay, it says, what is cardio fitness level on Fitbit? Cardio fitness is mostly a measurement of your VO2 max levels. VO2 max is regarded as the best indicator of cardiorespiratory fitness. VO2 max is a measurement of your body's maximal oxygen uptake, meaning the maximum amount of oxygen your body absorbs and uses during intense exercise. But other conditions such as resting heart rate, age, gender, and other pieces of information play their own role. Your Fitbit measures our overall cardiovascular fitness level by taking into account gender, age, weight, resting heart rate during exercise, VO2 max. And let's show this. We've got a graphic here. So it says, based on those criteria, other pieces of personal information and workout results, a Fitbit watch can determine your overall cardio fitness level. At the moment of writing this article, there are 6 fitness levels: poor, fair, average, good, very good, and excellent. The exact score represents those levels differ depending on most of the age and gender, though. Plus, overall, your cardio fitness level changes depending on how you perform overall, and that's basically what the cardio fitness level on Fitbit are. Let's see. How to see your cardio fitness score and levels on Fitbit. Fitbit automatically tracks your overall cardio fitness levels. All you have to do is to see them is go to open Fitbit app, tap on the Today tab and scroll down and choose the heart rate tile. I wonder if Chad deleted the app from her phone or if they even checked her phone. So there we got a graph of resting heart rate in the past 30 days. So this is really going to be interesting to see what the Fitbit data shows. Cardio fitness level. Okay. Most Fitbit devices track workouts and cardio fitness scores automatically. If your Fitbit does not automatically track exercise, use your Fitbit's exercise app to find and start an exercise. Fitbit does not currently include an option of adding manual workouts, so choose a workout category that's closest to the exercise you intend to do. Make sure to track your workout with heart rate tracking enabled and your cardio fitness level updates according. One thing to keep in mind is that running on flat terrain yields more accurate results. That's because running uphill makes your muscles and heart work harder to push you forward, and that can mislead the Fitbit app. Can I improve my score? Don't think that's relevant for our purposes. How long does it take to improve? 3 to 4 weeks. So you'd think that if her fitness was declining, that might also take some time. How do I get a more precise estimate of my fitness score? Ensure that you have a strong GPS connection and that you are on a terrain that's as flat as possible. Suddenly getting a low cardio fitness score, what gives? Was your score excellent yesterday and dropped to average today? First, let's check your weight, height, gender, and age information are correct in the app. Then let's look at your resting heart rate data. Usually, if it's unusually high, that could be why your cardio fitness plummeted seemingly overnight. Wear your Fitbit while you sleep to get a more accurate resting heart rate. If your score suddenly and radically changes, try restarting both Fitbit app and your Fitbit device. Also check for any updates to the Fitbit app and the Fitbit's firmware. Update it if available. Okay, let's see. My Fitbit cardio fitness score disappeared. Check that your Fitbit monitor and track your heart rate. You cannot get cardio fitness score without your heart rate. Oh, yeah, talks about fat burn cardio and peak mean, getting to know fitness level. Let's go back over here. Take a look and see if there's anything else interesting that we can learn. Okay, here, we've got an article. How data from your wearable tech can be used against you in a court of law. When wearable computers can disprove what someone told police, you know you're living in a future that has arrived sooner than expected. According to Lancaster Online, a woman in Pennsylvania has been charged with knowingly filing a false report after forensic evidence and data from her Fitbit undermined her claim of intimate assault. This case should catalyze a national discussion about when and how suspects can or should disclose data from a wearable computing device. When wearable computers can disprove what somebody told police, you know you're living in the future, which, okay, they already said that. The court affidavit obtained by Lancaster Online indicated that data from her wearable fitness tracker showed that the woman in question was awake and active the entire night, including the time she told police she was sleeping. This wasn't the first time that Fitbit data has been used in a court of law. In November, Parmy Olson reported how Fitbit was used in a personal injury claim by a personal trainer in Calgary, Canada. In that case, the data from the activity tracker was used to establish a baseline reference for her fitness level compared to someone of her age and profession. Let's scroll here. In that case in Pennsylvania, however, Fitbit data was directly used to contradict a claim. Oh, here we go. Oh, looks like I need to reboot. Can you hear me? Or the court? I'm going to reboot because it looks like it lost this audio.
Fitbit account for Tammy Daybell. And we looked at trying to verify the account as Tammy's. We were able to use that or do that by using her email, tammy.daybell@gmail.com. And we also used her date of birth that was inputted along with the listed friends that was on her Fitbit site, which were three of her children, Emma, Leah, and Seth.
And that information is not showing on this slide, but was additional information provided through Fitbit.
Yes,
And then on this, we see a user created. Do you see that date on there?
on the user create, the second
Yes.
one from the top.
Yes.
Yes,
What did that indicate to you?
that was when the account was created.
And then if we look down a little bit, there's a paired date. I think it's the second from the bottom. And that is a different date than the top one, correct?
Yes, it is.
What did the paired date indicate to you?
To me, that indicates the most recent device that was paired with Fitbit.
So Tammy may have had an account before, but received a new device.
She may have had a different device and got a new device. Yes,
So when she got the new device, that would create a different paired date.
yes,
And were you able to see at the bottom there, the last sync date?
yes. The last sync date is 10/20/2019 at 2029.
And again, Tammy Daybell was pronounced dead on October 19th of 2019.
Yes, the day before this.
So the last sync date was the day after her passing.
Correct.
And this Fitbit device itself was never recovered.
It was not.
Outside of looking to assign it, who this device belonged to, you'd also talked about you were looking to try to find information regarding the heart rate. Can you talk a little bit about that?
So we're looking for the heart rate to determine a better exact time or a closer time that Tammy passed away.
And were you able to get information regarding the heart rate from the Fitbit? Return?
No, we were not. The device, as it's listed up there, is a Alta device, which I learned is their base model. It'll show the heart rate as it's going on. You can sit there and look and see the heart rate, but it does not record with Fitbit.
Then I think one of the other things you indicated you wanted to look at was possibly sleep patterns or any sleep data that was recorded.
Yes.
What were you able to determine in relation to the sleep data?
The sleep data was very sparse from day to day or month to month. Like it would, for an example, this may not be accurate, but it might show on the 17th that she slept for an hour and a half. On another day, it might show 20 minutes, but on most days, it didn't record any sleep patterns.
Did that lead you to believe that she did not routinely wear it at night?
That's what it led me to believe, yes.
So ultimately, were you able to gain much information outside of learning that she didn't wear it at night?
Beyond that, that was all I could figure out.
And then what were some of the other things that you looked at in relation to the Fitbit data?
So the other things that were provided were the step counts from day to day, month to month for the year.
And if we look at this next slide, can you talk about what we're seeing here?
So these are the steps per month that was recorded by Fitbit when Tammy wore her device.
And when we see it starting with October and goes down to January and then a grand total steps, was this January of 2019 through October of 2019?
Yes,
So it's going in the opposite order.
correct.
When you reviewed this, did you make any determination with regard to those steps in relation to your investigation?
So when I was reviewing the steps, the numbers to me looked fairly big, but I didn't know what that meant as far as activity. Was it above average, normal, or below? I wasn't sure. So looking at those numbers, I was able to also research via the internet and found out the CDC recommended guidelines were recommended to have at least 10,000 steps per day. And these were the amount of steps that she took for those months.
And out of those months, was she generally above average?
Out of all the months, generally she was above average. There were a few months that she was not.
And the months that she was not above average, was she close to the average?
Yes, she was.
Any indication to you that there were months that she severely slowed down in activity?
Nothing that was severely slowed down, no.
And when we look at that last month of October, again, Tammy was pronounced dead on October 19th in the early morning hours. Is that correct?
Yes,
So that is not the full month.
that is not a full month.
From your review of things, did it appear that she was on track to be above average for the month of October of 2019?
Yes,
Did you look at any additional things in relation to Tammy's health? Outside of the Fitbit?
Mm,
And maybe I'll back up. Did you conduct any interviews with anyone that knew Tammy?
yes, I did.
Did you conduct interviews with friends and family of Tammy?
Yes,
And through those interviews, did you learn anything that would support the statements made by Chad Daybell on October 19th of 2019 regarding Tammy's health?
no.
Generally, what did you learn through your investigation regarding Tammy's health?
Found that she was reported as being very active, a go-getter.
That's Blake.
When you conducted the interviews, did you interview multiple of Tammy's friends or coworkers?
I did.
Did you interview some family members?
Yes,
Out of everyone you interviewed, was there any indication that Tammy's health was slowing down?
none,
Was there any indication that Tammy had seizures?
none,
Any indication Tammy had low blood pressure?
no,
Any indication Tammy had fainting spells?
no,
So from all the interviews you conducted, anything to support the statements made by Chad Daybell on October 19th of 2019?
there was none.
As part of your investigation, we talked about some life insurance policies that Tammy had. And we've gone over the life map a little bit, and I believe you already testified, but there was another life insurance policy.
Yes, there was.
And what was that one?
Primerica?
And Your Honor, I have what's been marked as States Exhibit 122. It's my understanding that this is being admitted by stipulation, and it contains the business record certification.
All right, exhibit 122 has been offered. Is there any objection? All right, it'll be reviewed by council.
And I will indicate there's a copy for counsel, the court, and a courtesy copy for Your Honor.
Thank you.
And Detective Mattingly, I'll just have you look through those pages. And do those appear to be an accurate depiction of documents you reviewed?
They are.
And in relation to the life insurance policies, were you able to determine the total amount of life insurance on Tammy Daybell?
Yes.
What was the total amount of coverage?
So on the Primerica insurance, it was 300,000.
And do you recall in relation to Life Map what the total was?
130,000.
And when you looked at those policies on the Primerica, was Chad also an insured?
He was.
What about the Life Map? Was Chad also an insured? Only Tammy?
Only Tammy.
Who was Tammy's beneficiary for the Life Map?
Chad Daybell.
Who was Tammy's beneficiary for Primerica?
Chad Daybell.
Through the investigation, were you able to determine if that life insurance was ever paid out?
Yes.
And what did you learn?
I learned both of them had been paid out.
And who were they paid to?
To Chad Daybell.
I have no further questions at this time.
All right, thank you, Ms. Blake. Which one?
I guess I maybe do just need to clarify, was that last exhibit admitted?
I don't think we actually got that admitted on the record, so you reviewed it. Is there any objection to it being admitted? We've now discussed.
I just don't know if we officially put that in the record, so I would move for its admission.
Thank you, Ms. Blake. It is admitted now. Thank you.
Thank you.
Good afternoon.
Let's try that again. Good afternoon,
There you
detectives.
go. That sounds great. Thank you. Good afternoon.
Um, You mentioned that you had reached out to speak to the family members, the immediately family members, and you know who those are, right?
Yes,
You know about Emma,
I
right?
do.
What are the dates and times that you tried to reach out to Emma to talk to her about this case and the Fitbit and all of that?
I'd have to go back and look. I couldn't tell you that.
You have
exactly.
notes to go back and look that could refresh your recollection?
I might, yeah.
Okay, those at the prosecutor's table?
Yes, they are.
With the court's permission, could I allow the detective to refresh his recollection?
Yes.
Your Honor, could I ask for that last question to be repeated back?
Go ahead.
Could I have the one before that? Thank you.
And it'll be the one before that, I think, too. Thank you.
I
You
don't
ready?
have those dates.
I'm sorry?
I don't have those dates.
Oh, you don't have any dates in your notebook reflecting that you tried to speak with Emma Murray?
No,
Do you have any recordings or any body cams or anything that would help you in determining whether you actually ever did talk to Emma Murray?
yes, those were recorded.
Those were recorded?
Was recorded, yes,
Attempts to talk to Emma Murray?
yes.
Okay, but you don't know the times.
I don't.
You don't know the frequencies. The frequency with which you talked to her, how many times?
I talked to her one time.
Do you know what time that was?
It would have been in the afternoon after school.
Yeah, what month was that?
No, that was so long ago, I can't tell you an exact month.
Okay. You approached her after school?
I did.
Okay. Did she try to talk to you?
No,
And that was recorded, you said?
yes,
And how was that recorded? By body cam or an audio?
audio.
And you still have possession of that audio?
Yes, we do.
Let's move on to Garth. How many times did you try to talk to Garth?
I was not assigned to talk to Garth.
Okay, so you never spoke to Garth about
That one I
any of
did
these.
not.
You didn't talk to him about this Fitbit or anything else, right?
No,
Okay. And you're the one who was the responsibility to do the research and the investigation on this Fitbit, right?
yes,
Okay. Okay. And as far as the insurance is concerned on their mother and Chad, that area was within your exclusive purview as well. Is that correct?
we shared that.
With who?
That would be with some of the FBI to review the numbers.
Okay, but essentially you were the contact guy and the initial guy to look into it. Is that right?
Yes,
Okay. So you didn't talk to Garth. What about Joe Murray?
no, that he refused as well.
Okay, he refused? When did you try to talk to him?
I did not.
Okay,
We split those assignments up.
okay. Okay, so Emma Murray is Chad's daughter, right?
Correct.
And Joe Murray is married to Emma, right?
Yes,
Okay, and you know Joe Murray because you went and the family you're talking about, you talked to Ed and Charlene Murray, right?
I don't know if I've ever met Joe, but I have.
I
met
didn't ask you
Ed.
that. I asked you whether you talked to Ed and Charlene Murray
That one, yes, I have talked to them.
and you interviewed them, right?
I did.
So when you're talking to the prosecutor about contacting the family to discuss this, really what you're talking about is the Emma's in-laws, right?
In addition to, yes,
In addition to who else in the family?
talked with Sam or Tammy's sister, Sam,
Okay,
and her husband, Jason.
okay. They didn't live in proximity to Chad, right? They didn't live within cllose proximity of
Close
Chad.
proximity? No, they did not.
Okay. And you're aware that Emma lived kitty corner from Chad's house, right?
At the time, yes. Mhm.
You're also aware that Emma and Tammy had a very, very close relationship, right?
I've heard that, yes.
Right. And Joe lives kitty corner with his wife Emma, directly kitty corner from Chad's house as well. Right?
Correct.
Okay. And you're also aware the other person you didn't talk to was Garth. And Garth actually lived with Chad and Tammy for a significant amount of time. You remember that?
I do.
You didn't talk to Garth though, right?
No,
Okay. And then Chad's other child, Seth. Did you ever talk to Seth?
no, I did not.
Okay. Did you ever talk to Chad's daughter, Leah?
No,
Did you ever talk to Chad's youngest son? Youngest son, Mark.
no,
Okay. But the last three, Garth, Seth, Leah, and Mark, you didn't even reach out to try to talk to them, did you?
I did not. That was for
Okay.
somebody else to do.
Okay. But nobody else reached out to talk to them either. Are you aware of that?
No, I believe they did.
Okay. I guess we'll see then, right? So the interesting thing I noted was that on the map, I think of the MapQuest insurance, it talked about the last known health issue, right? Remember that when the prosecutor brought that up with you?
I do.
Right, and he put down October 18th, right?
Yes,
Right, and you were aware by reviewing Officer Greenall's report that that was the night that Chad talked about Tammy throwing up and having cough fits, right?
yes.
So that would have been the last known health issue that she would have had the night before she passed away, right?
Objection, Your Honor. This misstates the evidence.
Sustained.
You're aware that Chad had to take care of Tammy in the middle of the night because she was having fits and throwing up the night before she passed away, right? Sir.
Pardon me. That's what I had heard, yes.
Okay, all right. Now, you reviewed the medical reports, correct, of Tammy Daybell?
I did.
And those were pretty sparse reports, right? Teton was only a couple of pages, right?
Yes,
Right. And on Teton, the first page, and the jury will have a chance to look at that, it talked about Tammy's anemia, right?
as a past history, yes.
Right.
Mm.
And it didn't show anything in the future that Tammy's anemia was ever cured or resolved. You never found any information about that, did you?
None was disclosed as being
Right.
resolved. It was just listed as past, meaning to me, it's done, it's over.
Well, you don't know if it's done or over. Are you a doctor?
I am not.
All right. Do you know whether anemia could actually be cured or not?
Through an online search, it says yes, it can be.
Okay. But it takes a certain amount of medication, it takes a certain amount of treatment, takes a certain amount of prescription drugs and a series of treatment to at least stabilize it. That's what you read, stabilize it, right?
No, I didn't read that about stabilizing.
Well, the question is, where's that medical history that she treated it and cured it?
I don't have that.
Well, you don't have it because it doesn't exist, right? Correct?
I don't know if it exists or not. We just don't have that.
Okay. But what you do have is that Tammy had a habit of not wanting to go to the doctors to get treatment for anything, right?
Objection, Your Honor. States facts not in evidence.
Sustained.
Are you aware that Tammy did not like to go to doctors and didn't like to get treatment for various medical maladies?
Objection, Your Honor. Calls for speculation.
Overruled.
You can answer that, sir.
Would you repeat the question, please?
Tammy didn't like to go to the doctor, right?
Correct.
Okay. And at the time that she was discovered to be dead, are you aware of all the herbal and medicinal medicines that were in her cabinet at that time?
Yes,
She was doing a lot of self-treatment with oils and herbs. Do you recall that?
I do.
Okay. Okay. She was also taking Prozac as a result of that, right? A result of some depression, excuse me.
Objection, Your Honor. Misstates the evidence.
Sustained.
Were you aware that she was taking fluoxetine?
I have difficulty with that as well. Fluoxetine.
Fluoxetine, thank you.
Yes,
I'll say it wrong 10 more times and everybody's watching me say that, right? Fluoxetine. You were aware she was taking that.
yes,
Generic form of Prozac.
yes.
Okay.
Mm.
And that was for depression. And in addition to taking the fluoxetine, she was also self-treating with essential oils, with herbs and a variety of other remedies, self-help remedies. You're aware of that as well, right?
Objection, Your Honor. Calls for speculation.
I'm asking if he's aware of it, Judge.
Overruled.
Are you aware of it?
Yes,
Okay. And you're also aware that at the time that Chad was interviewed, he was sobbing, he was crying, and he was emotional, right?
I heard that.
Yeah. And at the time that he was still able to say, listen, she had fainting spells, she had dizziness, she had all of those conditions that she described in Officer Greenall's report, correct?
Yes,
Now, your wife dies and you discover her because she falls out of the bed. You call 911 and then police officers start interviewing him.
Objection, Your Honor. That's a narrative. The state would move to strike.
Sustained.
So Chad's sobbing and crying, and you're expecting him to recite exactly what her medical history is at the time that he's emotionally distraught about his wife's death, right?
Objection, Your Honor. Argumentative, and it's a narrative.
Sustained.
The fact that that Chad Daybell was sobbing, would that be a position in your experience where someone would be able to effectively um, um, provide information about their medical history and all of the things that may have been going on with their wife?
through my experience, yes.
Oh, so when someone's emotionally distraught, they're able to recite everything in your experience, right?
Objection, Your Honor. Asked and answered.
Sustained.
And then we have Garth Daybell, who was described as quiet and reserved, and there really was no effort to talk to him, right? Right?
That I don't know.
Okay. And as someone who's going through shock, as described by, Brenda Dye, would you expect that he'd be also able to dictate or explain to you what his mother's health history is?
Objection, Your Honor. Calls for speculation.
Overruled.
You can answer it.
Given time, yes, through my experience.
Given time, right? After he gets over the fact that they discovered their mother dead on the floor, after that, you give him enough time, he could probably get around to it, right?
Yes,
Okay. You don't know how much time that would be though, right?
it varies from individual.
But your experience doesn't tell you that it's instantaneous, right?
Correct.
Right. Just like Chad Daybell sobbing, it's not going to be an instantaneous answer, is it?
Objection, Your Honor. Argumentative. Asked and answered.
Sustained.
Now, on the life insurance policy, the Primerica account, and let me know when you're ready. Good. Okay. On the life insurance policy, that Primerica account for the 300,000 was established in 2002, right?
April, I believe, yes, 2002.
And on that life insurance policy in 2002, Chad had one for Tammy, right?
Yes,
And Tammy had one for Chad.
yes.
And the beneficiary in the event that Chad passes away would have been who?
Tammy,
And in the event Tammy passes away, the beneficiary would have been Chad, right?
correct.
Okay. And they set that up back in 2002, correct?
Yes,
And there was no action on that, right? No other modifications or changes of any significance, correct?
correct.
Okay. And then we go to the map, I'll forget the word, MapQuest, I think it is.
Life map.
Life map, I'm sorry.
No, you're,
Life map, thank you. On Life map, initially the insurance was set at 50,000.
initially, yes.
Right. And as part of your investigation, were you able to determine that that 50,000 was the base that was available for someone in their first year of employment at the school district?
Yes,
Okay, so Tammy was automatically given the initial 50,000, right?
yes, she was.
And then after the first year, that's only where she would have been eligible for the additional upgrade to the rest of the insurance, correct?
She would be available, or she had that option to do so.
Right. She could have done it or she could not have done it.
Yes,
And that's very cost-effective insurance. Did you look into that?
it is.
Very inexpensive, right?
It is.
Okay. Now, you talked about not being able to locate the Fitbit. Can you tell me who was wearing the Fitbit on the 5 or 6 months that you put those numbers up on the board?
I cannot.
We don't know who was wearing that Fitbit. We don't know if it was Emma, right?
We don't know.
You didn't talk to Emma. You don't know who was wearing it.
I do not know.
You don't know how it was used or how it was. What you're doing is you're explaining to this jury that what you have are basically numbers, right?
I do have numbers.
And what you don't have is you don't have who was using it, how they were using it, or when they were using it, correct?
We know when they were using it.
Okay. Now, I know that you talked to Ed and Charlene, right?
Yes,
So you have some insight a little bit about Tammy and her use of that Fitbit, right?
I do.
Right. And as part of that, you were able to learn that there was a family competition when it came to the Fitbit. Remember that?
I do.
And do you remember when Charlene mentioned on the recording that you taped, and thank you for recording it, um, that Charlene said that she would go to bed at night and she'd be,
Objection, Your Honor. Hearsay.
Sustained.
were you able to gather some information as to the competition between Tammy and the rest of the family regarding the Fitbit?
Objection, Your Honor. Calls for hearsay.
Overruled.
Okay, you can answer.
Yes,
And at this point, you were also able to determine, as a result of this competition, that certain activities took place. Certain people would go to bed at night being ahead on their Fitbit device. You learned some information about that?
yes,
Okay. And through your investigation, you learned that that person was Charlene Murray, right?
correct.
Okay. And you also learned as a result that the next morning, surprisingly, Charlene would find that she was now behind on the Fitbit race, right?
Yes,
And um, do you recall which family members were involved in this so-called competition?
so if I remember correctly, there was Ed and Charlene and Tammy.
Okay. And in interviewing the Murrays, Ed and Charlene, this was a little bit of a Tammy was a competitive person,
That's what I understand, yes.
didn't like to lose, right?
Yes, correct, she did not.
Okay. But you don't know how that Fitbit was used when you calculated these numbers, correct?
Correct,
And you don't know who was using that Fitbit and running those numbers up, right?
I do not.
And you also don't know the manner in which those Fitbit numbers were accumulated on the particular device. Is that correct?
Correct.
Judge, I think that's all I have. Thank you.
All right, that concludes cross-examination. Ms. Blake, if you'd like any redirect, you may.
Thank you, Your Honor. Detective Mattingly, you've indicated it's fair to say this was a joint investigation.
Yes,
Which agencies were involved?
we had members of the FBI, Rexburg Police Department, Chandler, Arizona, and Gilbert, Arizona, along with Fremont County.
At some point, was the Attorney General's office also involved?
Yes, they were.
And when it came to, you were asked a lot about interviews with Chad's children just
Yes,
now.
yes,
And I think you'd started to say that different duties were split between different agencies and investigators. Is that fair?
that is fair.
Did you review and discuss the case with other officers?
Yes,
Based on your investigation and your understanding, did any of Chad's kids come forward with information?
Overruled.
Did any of Chad's children voluntarily come forward with information?
not one.
Do you recall attempting to speak with Emma about the results of her mother's autopsy?
Yes,
Would that have been around sometime in February of 2021,
it could have been, I don't know.
sometime after the autopsy results were received?
After the autopsy results, yes.
Was Emma willing to hear about those results?
No,
Was Emma willing to speak with you?
she was not.
Did Emma provide you any information about her mother's health at that time?
Nothing.
You were asked about knowing that Tammy didn't like to go to the doctor. Do you know where that information originated?
I believe that came from Chad and his children.
You didn't personally know Tammy. Is
I
that
did
correct?
not.
So the only information you had to go on is what was provided by Chad and or his kids.
Yes,
And you were asked similarly if Tammy would self-treat with homeopathic medications or other things. Do you know where that information originated?
that'd be through Tammy's family, Chad and her children.
So you don't personally know whether or not she used those homeopathic medicines
I
or
don't,
treatments,
I don't.
just what's reported by Chad and his children.
Yes,
Then talked a lot about the Fitbit. On that first slide, we saw that it was registered to Tammy's Gmail. Is that correct?
it was.
And I think you'd also mentioned seeing Tammy wearing that in Facebook photos. Do you recall that?
I do.
Any reason to believe Tammy wasn't using the Fitbit?
I don't.
And Your Honor, I'm going to ask if I can be handed State's Exhibit 152. Your Honor, it's previously been admitted. I would ask to be allowed to publish it.
You may.
Trying to make that a little easier to read. You were asked about Chad telling individuals on October 19th that his wife had become sick the night of October 18th. Do you recall defense counsel talking to you about that?
I do.
And then you were asked about the form and where he indicated October 18th of 2019 was when she first started having symptoms.
Yes.
And I know that's difficult to read, but under the medical information, can you read what is above where he wrote October 18th, 2019? And if you can't, I can have the exhibit handed to you.
No, I believe I can make it out. When did health of deceased first become impaired?
So it indicates when did the health first become impaired? Correct?
Correct.
And what was Chad's response again?
October 18th, 2019.
I have no further questions.
All right. I don't know if we got outside the scope of any direct or cross, so I'm going to deny recross. Conclude your testimony then. Is this witness going to be recalled by the state potentially?
The state would reserve the right to recall. Detective Mattingly.
Okay, so Detective Mattingly, you remain under subpoena. You may be recalled to testify in this case because of the court's exclusionary order. Please refrain from viewing any of the evidence that is presented going forward between now and the time you take the stand. Don't discuss your testimony or others' testimony between now and then, and I'll ask you about that when you retake the stand.
You wish.
All right, thank you. All right, the state can call its next witness.
The state will call Detective Kaikamanu.
solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Please.
All right, the court would note as the state's case agent, Detective Kai Kamanu is not subject to the exclusionary rules, so I won't make my normal inquiry. And Ms. Blake, you can proceed with your direct if you wish.
Thank you, Your Honor. Detective Kaikamanu, can you please state your name for the record?
Vincent Keone Kaikamanu. Last is K-A-A-I-A-K-A-M-A-N-U.
Where are you currently employed?
Madison County Sheriff's Office.
And I've been calling you detective, but what is your current title and or position?
I'm currently the Chief Deputy for Madison County Sheriff's Office.
At the time you were involved in this case, was your title detective?
Yes,
Are you okay if I call you detective today?
yes.
Where were you employed prior to working in Madison County?
Fremont County Sheriff's Office in Idaho,
How long were you employed with them?
about 18 years.
What was your title or position when you left the Fremont County Sheriff's Office?
I was a sergeant over detectives and school resource officers.
And what position did you hold prior to that?
I was a regular detective and then a patrol deputy prior to that.
Do you have any specialized training in order to be a law enforcement officer?
I do. I went through the Idaho Post Academy. I currently hold my intermediate, my basic, my advanced, and supervisor certificate. Throughout the years, roughly around 2,500 hours of training, and training is always ongoing.
And in October of 2019, you were working in Fremont County, correct?
Yes,
And what was your title at that time was detective?
yes.
Do you recall if you were working on October 19th of 2019?
I was the on-call detective that night.
Do you recall missing a call that night or
Yes.
in the early morning hours?
Yes.
Why did you miss that call?
Earlier that night, I was called out to assist Idaho Falls PD in an officer involved shooting incident.
Do you recall approximately when you were called out to assist in that?
Around 11 o'clock p.m. on the 18th.
And when did you finish up with your assistance in that matter?
I got home around 4:30 a.m.
After missing that call, at some point, did you end up making contact with the deputy?
I did.
And who was the deputy?
Deputy Allie Greenhalgh.
Did you learn why she had called you?
I did.
What did she call you about?
When I made contact with her, she informed me that she was on an unattended death.
And as the on-call detective, did you always respond out to an unattended death?
No,
When would you respond out?
we would respond if there's anything suspicious. After talking with the deputy that's on scene, we'd go over certain things. If there is anything out of the ordinary, any forced entry, anything wrong with the body, anything that was suspicious to them and out of the ordinary.
When you returned that call, well, let me back up. And what is an unattended death?
An unattended death is a death that's not under a doctor's care.
Is it typical for law enforcement to respond out to an unattended death?
At that time, for not all the time.
And if someone did respond out, was it generally a deputy to start with?
Yes,
And then if necessary, a detective would show up.
yes.
When you returned the call to Deputy Greenhalgh, did you learn if she'd been in touch with anyone else?
I did. I was informed that she had contacted Detective Mattingly. Mattingly?
When you reached back out to Deputy Greenalch, did you ask her questions?
I did.
What were some of the things you inquired about?
Kind of just what I spoke about. I asked her if there's, again, anything out of the ordinary, any forced entry into the house, anything that was different with the body that she thought was suspicious, things of that nature.
At that time, did she inform you of anything suspicious?
She did not.
And did you learn whether Detective Mattingly had made the decision to respond out?
I did,
And what did you learn regarding that?
that he did not respond either.
Do you know if there was anyone else on scene or anyone else that arrived?
Later on scene, I found out that Deputy Coroner and the Coroner of Fremont County was also on scene.
And who is it that determines whether or not an autopsy is performed?
The Fremont County Coroner would be the one.
And the Fremont County coroner was on scene to the best of your knowledge?
Yes,
And is it fair to say that on October 19th of 2019, outside of the initial response, no investigation was opened into Tammy's death?
yes,
And had you heard the name Tammy Daybell before October 19th of 2019?
no,
Had you heard the name Chad Daybell?
no,
Had you heard the name Lori Vallow,
no,
Alex Cox,
no,
JJ Vallow,
no,
Tylee Ryan?
no.
Subsequent to October 19th of 2019, did you become involved in an investigation into Tammy Daybell's death?
I did.
Do you recall approximately when you became involved?
I got involved with Tammy Daybell's death approximately around March of 2020.
Do you know when the Fremont County Sheriff's Office became involved?
They received a call for assistance of an Arizona PD, Gilbert PD, October 31st, 2019.
When you became involved in March of 2020, were there other related investigations pending?
Yes,
What were those?
there was the homicide of Charles Vallow in Chandler. There was the search of the two missing kids, JJ and Tylee, and the attempted shooting of Brandon Boudreaux.
Is it fair to say that this became a joint investigation?
Yes,
Did you assist with other aspects in those or some of those other investigations that were related?
yes.
Specifically, which ones did you assist with or which one?
My main focus was Tammy's, and then I did assist with locating and helping with JJ and Tylee.
As part of your investigation into Tammy's death, did you review an incident that had happened earlier in October of 2019?
Yes,
Do you recall the date of that incident?
that was October 9th, 2019.
Were you personally involved in that investigation on October 9th?
I was not.
So after the fact, you looked into that.
Yes,
As part of that, did you review police reports?
I did.
Did you also review a call into 911?
I did.
And did you review a dispatch call?
Yes,
And do you recall what the nature of the report from October 9th of 2019 was?
it was a suspicious event, and our deputies were dispatched to that.
And did it involve a report of a gun or a paintball gun being pointed at someone?
Yes,
And Your Honor, I believe both of those calls were admitted into evidence yesterday, and I was going to see if I could get both of those exhibits. And Your Honor, those have already been admitted as exhibits. I'm going to ask to publish State's Exhibit 232A.
232A can be published.
Where's your emergency?
Yes, so my mother-in-law, who lives in Columbus, had just gotten home about 10 minutes ago, was unloading her car, and she thinks the man, but she's not 100% sure she didn't see, because they were wearing a mask, came up to her, put the table again, but they started shooting at her. It wasn't loaded, so it didn't, he didn't know they came out of it. But he kept asking what he was doing, he would respond, and then suddenly asked us to pull out with husband who ran off.
Okay, what's the address? Are you there? Hello? Are you still there?
Yeah, can you hear me?
Okay, now I can hear you. What's the address?
It's 199 North, 1900 East, Rexburg, Idaho, 83440. That's my address. She lives in Big Corner. I don't know what her address is.
Okay, I need her address. What's her location?
I think it's 201, I think is her address.
201 North 1900 East?
North, yep.
Does she know which direction he ended up running?
We headed east, back behind their house.
Okay, and did she give you a description of the clothing?
I didn't get one from her. I can follow that.
What is your name?
My name is Joseph Murray.
Okay, is this a good phone number for you?
Yep.
Okay, I am sending a deputy out to your mother's home.
All right, thank you.
You're welcome. Bye-bye.
Bye-bye.
And Your Honor, I would next ask to publish State's Exhibit 232B.
You may.
I apologize. Now I'm having tech issues.
October 9, 2019, 21 hours, 49 minutes, 20 seconds.
Fremont County Sheriff's Office.
Hi, I need to report something.
Okay, go ahead. What's the address?
Okay, at 202 North, 1900 East, the corner with the blinking yellow light on Salem Highway.
Is it a suspicious person?
Yes.
Okay, what was he wearing?
He was all dressed in black and he had a ski mask on.
And he's at the blinking light now is where you saw him?
No, he's gone now because I pulled up into our driveway and I was getting stuff out of the back seat of my car and suddenly he was there and he had a paintball gun and he was and he was going to shoot at me. And I kept asking him what he was doing because I could tell it was a paintball thing. And then he just kept doing it. So I yelled for my husband and then he took off running around the back of my house.
Okay, give me just 1 minute. Stay on the line with me.
Okay.
October 9, 2019, 21 hours, 50 minutes, 28 seconds.
And that was North 1900 East.
Yes.
October 9, 2019, 21 hours, 50 minutes, 43 seconds.
Do you know what direction he was going?
He went behind my house and it showed dark out there and I just went in the house and got my husband and son. And then they went out and looked and he was long gone by then. So he was on the north side of my house. Is where he went to get away.
Okay.
He didn't say anything or he just kept like he was holding the gun like he was, had a rifle and was shooting at me. So, but nothing came out of the gun either. So I don't think it was loaded.
Okay, and what is your name, ma'am?
My name is Tammy Daybell.
Okay, I will pass your information on to my deputies. We actually just had a previous call about this individual, so they're out in the area looking now.
Okay, yeah, I think it was my son-in-law who lives diagonal from us that called you guys already.
Oh,
So I
okay.
just wanted to make sure it got reported. So
Let's see. And what's your son-in-law's name?
Joseph Murray.
Okay, yep, it was him.
Okay.
So, all right, I have a deputy that will be out at your home here shortly.
Okay, thank you.
Yep.
And I can hand those back to the bailiff, Your Honor.
All right, thank you.
Detective Kaikamanu, do you recall reviewing those calls?
Yes,
And particularly, there's the call from Tammy Daybell into dispatch. Is that correct?
yes,
And she describes the incident.
yes,
Did you hear how she referred to the weapon?
yes.
How did she refer to it?
When she first called in, she referred to it as a paintball gun. Throughout that conversation with dispatch, she also describes it as a gun and a rifle.
Did you also, I think you've already said, but did you review the reports in relation to that incident?
Yes,
Are you aware of a search that was conducted on an apartment associated with Alex Cox in Rexburg?
yes,
Were you part of that initial search?
I was not.
At some point, did you learn of some firearms that were recovered during that search?
I was aware.
What, if any, action did you take in relation to those firearms that were recovered?
From my understanding, those firearms were taken by Rexburg PD for safekeeping. After the search warrant was served, they could not leave those there. During the investigation on the attempted shooting on Tammy Daybell and then her death, I ended up writing a warrant to seize those weapons and bring them into Fremont County for evidence.
Did you in fact seize those firearms?
I did,
Do you recall photographing one of the firearms?
yes.
Your Honor, I have what's been marked as State's Exhibit 281A. I have a copy for counsel, a courtesy copy for Your Honor, and the exhibit. I would ask that the witness be shown a copy of the exhibit. And Detective Kaikamano, do you recognize that firearm?
Yes,
Is this in fact one of the firearms that was seized?
yes, it was.
What about this particular firearm caught your attention, if anything?
The ones that were seized, this one, to me, looking through them resembled or could be looked at as a paintball gun during this incident of the attempted shooting on Tammy.
And Tammy had also used the word rifle.
Yes,
Is this in fact a rifle?
it is.
Did you take this photograph?
I did.
And is it an accurate depiction of the firearm seized?
Yes.
Your Honor, I would move for the admission of State's Exhibit 281A.
No
Any
objection, Judge.
All right, Exhibit 281A is admitted.
And Your Honor, I would ask to be allowed to publish.
You may.
And Your Honor, just to have a clear record of it, the state had begun to publish our copy. I've swapped that out and we have published the official exhibit,
Okay. thank you,
but it
Ms.
was an exact copy of it.
All right, we'll note the actual exhibits now being published for the jurors.
Thank you, Your Honor. Detective Kaikamano, I believe there is a laser pointer up there if that's helpful. You indicated that this could resemble a paintball gun. I want to talk to you a little bit about your experience with paintball guns. What experience, if any, do you have with paintball guns?
Growing up, I shot paintball guns all the time. And then getting into my law enforcement career and getting on the SWAT team, we utilize paintball guns and paintball rifles that are set up similar to AR-15s for our training.
And what experience do you have with assault rifles?
Again, before my law enforcement career, I'd shoot them. And then once I got into law enforcement, we were issued a AR-15 and we would train with them. We train with them in SWAT training and we go to the range and shoot.
And you talked about that you were issued an AR-15. What is different between this and an AR-15?
So this rifle that you guys are looking at is actually 6.5 Grindle. The ones that I was issued is an AR-15 that shoots 223s or 5.56. So the caliber is just that different. The lower is all the same. You just need to switch out the upper.
And based on your experience with both assault rifles and paintball guns, what part of this firearm did you believe could appear to be a paintball gun?
So if you look right here where this scope is, it is on the top of the rifle. On a paintball gun, the hopper is sometimes off to the side a little bit, just right about there on the rail. But in my experience, they've made paintball guns so advanced now that it could be on the top or on the side.
And do they make some paintball guns to resemble assault rifles?
Yes.
And what is the hopper on a paintball gun? What's the function of the hopper?
The hopper on the paintball gun is where you put your paintballs inside, and that's what holds them. And when you shoot them, that's what comes out of the barrel.
And we will come back to that exhibit in a bit.
And Judge, could I have again, a reminder of what number that was again? I have a 281A, is that correct?
That is
Anyone-
correct.
Yeah.
Thank you, Your Honor.
As part of your investigation, we talked earlier that on October 19th of 2019, you had not heard the name Alex Cox. Is that correct?
Correct.
At some point, did you learn the name Alex Cox?
Yes.
And was that through the investigation?
Yes.
Who was Alex Cox in relation to Chad Daybell?
Alex Cox was Chad Daybell's brother-in-law.
And before Chad and Lori were married, what was the connection between Chad and Alex?
Before they were married, I couldn't tell you.
So Lori Vallow is the connection between the two?
Lori Vallow.
And ultimately they became brother-in-laws?
Yes.
As part of the investigation, do you recall looking at an account, some searches done on a Homer J. Maximus account?
Yes.
Who was that account associated with?
Alex Cox.
And you did review some of the data in relation to some Homer J. Maximus searches, correct?
Yes, I already reviewed some of it.
Did you review the whole thing?
I did not.
Did you focus on a specific time frame?
Yes.
And what time frame did you focus on?
Roughly around the time of the shooting or the attempted shooting, excuse me, on October 8th, 2019, and a few days after that.
Is it fair to say that there were quite a few searches on this account?
Yes.
And were there other searches on the days that you reviewed?
Yes.
In preparation for your testimony today, did you create an exhibit?
Yes.
Do you believe that the exhibit would assist in your testimony today?
Yes.
Do you believe it would aid the jurors in understanding?
I do.
Your Honor, I have what's been marked as States Exhibit 107B. Similar to others, it is on a jump drive, but I do have courtesy copies of the slides printed for counsel, the court, and Your Honor. And I would ask that the witness be shown the printed out 107B.
Thank you.
And if you could look through those slides, Detective. Do those appear to be an accurate depiction of the PowerPoint created?
Yes.
Your Honor, I would move for the admission of States Exhibit 107B.
Any objection?
Judge, for demonstrative purposes, there won't be an objection.
All right.
And Your Honor, this is a summary exhibit.
Okay, as a summary exhibit, Exhibit 107B has been admitted.
Thank you, Your Honor. I would ask permission to publish.
You may publish.
And Your Honor, I have the HDMI cable plugged in, but this is not my screen showing.
Okay, we will see.
And Your Honor, I'm just looking at the time. I will indicate it's still not showing my screen.
Yeah.
And so where it is 3:17, I don't know if the court would like to consider convening early today, and I will work with IT to make sure that I have it ready for tomorrow.
I do
Judge, there
think,
won't be any objection to that. I
Okay.
understand.
thank you. It does make sense. We've got some kind of a tech gremlin going around. This, we'll try to sort that out for tomorrow. Council, work with tech. So with that, we are going to conclude evidence for the day. Council, as we do that, and for the jurors, I want to indicate some information on our schedule going forward. Tomorrow, well, I'm going to hear some motions outside the presence of the jurors this afternoon. Once we come back on the record after the jurors have been excused, I'm inclined to be able to make rulings tomorrow morning on those motions. That may take a little bit of time, so my proposal would be to start evidence tomorrow morning at 9 with the jurors instead of 8:30. Is the state okay with that?
That's fine with the state, Your Honor.
No objection, Judge.
Okay. In addition, ladies and gentlemen of the jury, we've got some court staffing issues leading us to take one of our days off next week. And since we know that already, in order for you to make any plans you might on a day off, I'll advise you that we are not going to be conducting court on Tuesday, which I believe is April 30th. That will be a day without trial next week. Otherwise, our schedule will remain as it's been going forward. So that'll be the schedule upcoming in the next several trial days. Ladies and gentlemen of the jury, then, before we conclude for the day, again, please make sure to follow the court's continuing admonition to not investigate the case, watch media or news coverage of the case. Please don't discuss the case amongst yourselves or with anyone else until you return tomorrow. Thank you for following that admonishment each day. And again, I'll leave it to the marshals who arrange for your arrival times to modify that if it needs to be for the morning, where the jurors won't need to be here for evidence until 9 o'clock. So thanks everyone in the courtroom also for following the courtroom conduct order. And with that, we will go ahead and conclude for today.
All rise, please.
Okay, well, I think that's it. They said there's going to be some motions, but they didn't say whether. Let's see what happens. Oops, something's not muted.
Thank you. Please be seated. Council, in terms of going back on the record for the motions, let me just first clarify, the two motions in limine will go on the record, yeah. Thank you. The motions in limine are still at issue and to be argued, is that correct? Sorry, Ms. Blake.
No, that was my fault, but I did just realize we still have the witness on the stand. Would the court like to excuse him from the stand?
Yeah, well, I'll be very quick here and then
Okay.
we'll all just break for the day.
Yes, I believe we're ready to move forward on those motions in limine, and Mr. Wixom will be addressing them.
Okay, I am going to take a quick break then between now and the time we argue the motions, council. And then if those in the courtroom want to watch the motions, those are, we've determined to be public motions. I'm going to suggest we start those in about 20 minutes at about 20 till 4 to argue those motions, as well as the issue the court raised about designating any victims in the case. So that'll be our schedule. We'll take a 20-minute recess here, come back on for those motions. Thank you.
All right. Okay, well, I guess I will keep the stream going for those motions since they will be public. Otherwise, I was ready to run over and empty out my SUV, which is, I've been waiting for the title so that I can sign it over and it can be hauled away as salvage. And the title finally came, and I just need to get over there and sign it over, and then the mechanic will arrange for the salvage guy. But I guess I got a little while to go yet. So let's see. I was looking and saw that the murder charge finally came down for that little gal, Madeline Soto. So maybe while we're waiting, we'll take a look and see some news on that. We've got the full hearing. Okay, here's something that's let's take a look at this from Court TV earlier. Oops.
The state of Florida by the state attorney there. And this is regarding Madeline Soto, who you have heard about, and the child. And Stearns is the one who had been charged with pornography. Let's get you live into the presser.
7.5 weeks, actually. The Kissimmee Police Department and my office have been working closely to go over every piece of evidence that we could gather in this case. It was a voluminous and a lot of evidence to get through during that time, but we were successful in getting through it and making sure that we were able to provide on the best case we could. Today, we're announcing that Stephen Stearns has been indicted by the grand jury on first-degree murder for the killing of Madeline Soto. We presented the case to the grand jury. They returned an indictment earlier today. There has been some questions as related to the length of investigation. I just want to let you know again that my office and the Kissimmee Police Department have been working vigilantly in making sure that we had every opportunity to get every piece of evidence that we could. I want to thank the Kissimmee Police Department and their tireless efforts. They've done an amazing job in the heavy lift that we've asked them to do, as well as the prosecutors that have been assigned to this case and making sure that we got every piece of evidence reviewed and gathered in this case. While death investigations usually take around 5 to 6 weeks or longer, we were able to get this one done relatively quickly and get the case to the front of the grand jury, like I said earlier today, to return the indictment against Mr. Stephen Stearns. The death penalty in this case, we have not decided to what decision we're going to make in that case. We're going to continue those discussions going forward, and we'll let you know again when we make that decision as to whether we're going to seek the death penalty in this case. I want to thank the grand jury for their hard work and their efforts in making sure that we're taking this first step in seeking justice for Madeline Soto, for her family, and so this the community can have closure in this case. Excuse me. The defendant will appear at initial appearances, I believe probably the next day or two. Then the case will proceed down its normal path, and we'll try to keep you abreast of how the case is moving, as well as you probably ask us questions to make sure that we are providing that proper information to keep you abreast of how the case is going down and then the normal path of the criminal justice system. I'd like now to introduce Chief of Police Betty Holland, and for her to provide comment.
And uncovering the evidence to move forward with this case. We know this case has gained significant public attention because Madeline had just celebrated her 13th birthday and was just a child. The evidence shows an individual that was entrusted to keep Madeline safe. They calculated the need to put Madeline one day following her disappearance, the emergency was actively found Madeline safe. First, Madeline's remains were found. Our detectives have worked tirelessly to keep together the events leading up to Madeline's disappearance and death. With the collaboration of the state's attorney's office, we prepared the case for the grand jury that was heard today. The grand jury determined that our department secured enough evidence to obtain a first-degree murder indictment. We appreciate each grand jury member for their careful consideration. We want to thank the diligent work of the state's attorney's office, the medical examiner's office, and our other law enforcement partners who assisted with this investigation. Your expertise and dedication were instrumental in uncovering the truth. The indictment signifies a crucial step forward in our quest for justice and a testament to our commitment to honoring Madeline's memory. We will now take questions.
As far as actually, while respecting the cause of death from Madeline Soto, now that you have this.
Right, I'm going to defer to the state's attorney.
Good afternoon. Although an indictment has been returned this afternoon, it is still an open and ongoing criminal investigation. So much of this information cannot be disclosed until Mr. Stern's attorney, if he does so, elects to participate in discovery, and then all of you in the media know how to go about seeking information records. Was there anyone else in that house?
Not that we've uncovered.
Again, all questions about the facts of the case are not subject to disclosure because of public records laws at this time. Once his attorney participates in discovery, then you can make public records requests through your normal channels as you do in other cases.
What is the status of the investigations in regards to the mother? Something you can share about it?
At this time, the only person being charged is Stephen Stearns. And again, this is not over. There is an ongoing investigation to uncover more evidence, and therefore we can't comment. There's going to be the same response on any question about the facts of the case.
Can we determine?
Through the facts of the case.
State attorney, what factors have to be considered before you decide to get that?
So with any death case that is reviewed by my office, when it's determined to be a homicide, we have to look at the statutory aggravating factors that are laid out in our Florida law. But once we determine that we have sufficient evidence to prove those factors to the proper evidentiary standard, then we have to have a talk about whether this is a death penalty case. And that's a discussion that we're still going to be having for the next couple of weeks to make sure that we're making a legal decision that's appropriate in this case.
Leading up to this, have there been any plea discussions with Mr. Stearns? There's so many other factors there with people you guys are looking into and people decided.
I'll leave that for Mr. Will.
Cannot comment on whether Mr. Stearns is doing anything. He has counsel. And as far as plea offers, no, there are no plea offers made on the You can address that question with the indictment. That should be on the website if it's not already.
for his state's attorney.
Again, any question about the facts of the case, it's going to be the same answer. Once his attorney participates in discovery, the public records laws change. We'll be able to get a lot of that information.
But you mentioned it's an ongoing investigation. It's already filed against her. What about those 60? Anybody else involved with those 60 charges, or is that concerned? Are you guys focused that's just Stern? Already.
As far as the 60 counts that are already filed against Mr. Stearns, that is solely involving Mr. Stearns as the defendant. Not to those 60 charges.
All right, Melanie Soto, you may recall, was reported missing a few days later. She was found in rural Florida after she was reporting Missy and Madeline Soto, apologies, and she had been murdered. And I just have to comment, Michael, now he's charged with her murder. Prior to today, he had been charged with sexual battery, molestation, and child porn-related crimes dating back to 2019. She would have been 8 years old at that time. I know there's a presumption of innocence. I got to tell you, I don't really care. Throw away the key. And they better make darn certain this is the mother's boyfriend in the home, that mother didn't have occasion to have realized something was amiss.
I think that's what they're talking about generally when they're talking about the case and investigation still being open, trying to figure out what role the mother may have played. Again, we don't want to cast aspersions on her. We also know these folks tend to be in groups, so maybe other people were involved, but you're absolutely right. Based on videos and photos found on his phone, 60 charges.
60
of child abuse, child pornography, all kinds of things. This child was just 8 years old when it began. Quickly, they were talking about making a decision on the death penalty. You heard the prosecutor say a decision hasn't been made. They're going to look at aggravating factors. I can tell you from looking at the statute, some of the aggravating factors, prior criminal history. Not sure this guy has an extensive violent criminal history. He was a person within the custodial position.
Which is an important
aggravating factor. And it was a child under the age of 12.
Yeah, all those
So,
things
all
matter.
those things,
And they did the math and said that there could have been at least 400 images of child porn. So you put that all together, I think he should be looking at the death penalty.
Yeah, I have no doubt that they're going to come back.
Yeah, this is a horrible, I mean, it's just all, good for them.
Yes.
The indictment this morning, again, for first-degree murder against Stephen Stearns, the boyfriend of the mother, now accused of murdering Madeline Soto.
Okay, well, I don't know. The fact that the mother isn't cooperating doesn't bode well. Let's see. Okay, let's go back over to our graphic over here and see what else I can find on Madeline Soto. Okay, let's look and see this report.
First at 5, the prime suspect in the Madeline Soto case is now charged with murder. Stephen Stearns is the boyfriend of Maddie's mother. He's now accused of killing the 13-year-old girl. West 2's Osceola County Bureau reporter Megan Mulatto is live at the sheriff's office tonight. And Megan, we heard from authorities within just the last hour.
Yeah, we did. So State Attorney Andrew Bain says that his office and the Kissimmee Police Department spent the last 7.5 weeks sifting through evidence. They then put a case together, which was presented to a grand jury, which came back with a decision to charge Stearns with first-degree murder. Now, Madeline was reported missing in late February, just after her 13th birthday, when she didn't show up for school. The Kissimmee police chief says evidence shows Stearns had thrown away some of her belongings and even got rid of her body before she was even reported missing that day. Now, as law enforcement searched for Madeline, they found photos and videos on Stearns' phone that led to his arrest on 60 child sex crimes. Madeline's body was found in a wooded area in Osceola County on March 1st.
Our detectives have worked tirelessly to piece together the events leading up to Madeline's disappearance and death. With the collaboration of the state's attorney's office, we prepared the case for the grand jury that was heard today. The grand jury determined that our department secured enough evidence to obtain a first-degree murder indictment.
Now, neither the state attorney's office or the Kissimmee Police Department would answer our questions regarding the facts of the case or the events that unfolded. They say it's still an open and ongoing investigation. However, State Attorney Andrew Bain did say that his office still hasn't decided if the death penalty will be pursued in this case. Stearns did have a hearing this morning regarding the 60 charges he's facing, but he didn't show. Bain tells us that he should be back in court within the next couple of days for his first appearance on the murder charge. For now, we're live in Osceola County. Megan Mulatto, WESH 2 News.
Let's take a look back at how we got to this point. 13-year-old Madeline Soto was reported missing on February 26th. 2 days later, Stephen Stearns was arrested on charges of sexual battery and possession of child sexual abuse material. A day after that, investigators say Stearns was the prime suspect in her disappearance, and the teen's body was found in a wooded area in St. Cloud. Then on March 12th, 60 new charges were filed against Stearns, many of them related to sexual battery and molestation.
Okay. Let's go back over here and I'll look and see what else we may have that's newsworthy. Oops. That's the wrong tab. Okay, we should be going back to hear that motion in limine. See what it is that Pryor wants excluded. I do hope we get a Fitbit expert than her steps. It says new arrest for Kansas moms murdered in Oklahoma. Paul Grice charged. Let's see, still looking. Okay, this sounds like it's the mother's. Dr. Todd Grande featured the. Oh, here we go. Back on the record.
Three separate motions to take up this afternoon. Actually, two motions. One is a notice from the court on a issue relating to designation of victims. So as first initial comment I'll just make, we did get these motions in limine under seal, and I did find it was a to first. We were at the time, we did not yet have a jury seated and impaneled, and we do now. Secondly, there are still some unredacted personal identifiers contained in some of the exhibits that go with the motion. Things today. In addition, as I mentioned, we had the issue that came up on the court issuing an order with the request that we discuss the designated, if any, victims for the case for purposes of both sorting out the exclusionary rule and who that applies to, as well as any potential victim impact statements that may come into play in the case. So there are two motions from the state, and I don't really necessarily have a preference as to what order we take those up in. Maybe we could start with the designation of victims in the case and then move on to the motions in limine. Who would be arguing, if there is any argument for the state in terms of whether or not a designated victim would be appointed in the case for those reasons? So who from the state will address that?
I can, Your Honor.
All right. The court did send out a notice, basically just requesting clarification of that, where we're at in this stage of the proceedings. I'd like to know if the state is intending to make any designation of victim. Victims are designated by Idaho Code 195306, as well as the State versus Shackelford case does some analysis of that. We dealt with that in our previous trial. Other victims simply qualify based on familial relationship, but the designation is something that needs to be determined by the court. So, Mr. Wood, if you'd like to address that, I'll hear from the state.
Thank you, Your Honor. In terms of designated victims, or I think trying to remember the terminology used last year, but the victims who stand in the place of someone else, we would ask again that Kay Woodcock be allowed, as she was in the last trial, to stand in for Charles Vallow. Last year, Summer Shiflett had been a designated victim representative for Tylee Ryan. This year, that would be Annie Cushing, who actually has the same relationship to Tylee Ryan, just through Tylee's biological father, Joseph Ryan, who's deceased. Other than that, all the victim information would be the same as it was in the co-defendant's trial.
Okay, and to be clear then, the Annie Cushing would be the sole designee, right? We're not asking for multiple designated.
We're not asking for multiple designees. There would be other victims related to Tylee Ryan, such as her brother Colby.
Okay,
But in terms of the designee, just Annie Cushing. That's it.
okay, thank you. Does the defense have any input or statement or argument on the issue, Mr. Pryor?
Judge, as far as the designation of Kay Woodcock and Annie Cushing, I don't think I have an objection to that.
Okay, counsel, without walking through, I would incorporate the analysis. It wasn't the other case, but we did an analysis through an order in the case previously. I think I've got a printed copy of that order here. In case CR 2221-1624, State of Idaho versus Lori Vallow, some of the same people here. And in that memorandum decision and order talking about and the court's order excluding witnesses and reviewing both Idaho Code 195306 and State versus Shackelford 155 Idaho 454. The court incorporates that analysis and without objection would determine that Kay Woodcock would remain as a designated victim in the case and not subject to the exclusionary rule. Also permitted to make a victim impact statement if the case ends there. And that becomes an issue. In addition, that Annie Cushing, based on that relationship that's been not objected to, the court also finds it's proper as a designated victim under both the statute and the Constitution. So I'm trying to recall, I think there may be a form through the prosecutor's office that victims form that a victim witness coordinator would provide or something, but I'll make the record here on this ruling. And then if there's any follow-up we need of any further submission, we'll either advise the state or the state can just get that filed.
And it was my understanding that those had been filed, but if they have not, or if there's any clarifications needed, we will certainly take care of that.
Okay, that will conclude that issue then as it relates to defining victims in the case. So then we've got remaining the motions in limine, and I'll note that there are two separate. There's a motion in limine filed March 4th, 2024, and that relates to a proposed statement the state seeks to introduce relating to a statement made from a witness, Janice Olson, regarding Tammy Daybell's life insurance coverage. The other motion was filed March 14th, titled the second motion in limine, and that as it relates to statements the state wishes to introduce through testimony of witness Janet Anderson relating to alleged statements about Tammy Daybell being called, quote, or that she is a zombie is the quote. So why don't we start procedurally then with the earliest filed motion first on the life insurance and Janice Olson, and I'll hear your argument on that, Mr. Wixom.
Thank you. Would Your Honor prefer that I do it from the table or the podium?
The table's fine, Mr. Wixom.
Thank you. Your Honor, I won't assume that given the breadth of this case and the time that's passed that the court has these motions memorized, but I do intend to simply provide a brief overview and then respond to any questions or inquiries the court might have.
All right.
Judge, with respect to this first motion to eliminate, I think as explained in the motion, Janice Olson was a coworker of Tammy Daybell's at the school that she worked at. Apparently, at least a friendly acquaintance, if not a friend, someone that she had lunch with and visited with and talked to. Janice Olson, back in, I believe, May of 2020, was interviewed by Detective Bruce Mattingly. In that interview, she had explained to Detective Mattingly that by her timeline, her best estimate, roughly, I believe it was a month before Tammy passed was the time that she attached to it. She and Tammy had been visiting at the school, and Tammy had made I'll characterize as a passing comment to the effect that my husband wants me to up my insurance. Something to the effect of, I'm getting closer to retirement, but he wants me to up my insurance. Subsequent, we believe to that, and perhaps the application was filed before the conversation. We aren't certain, but they were clearly close in time because this occurred the first part of that school year. An application was submitted to the appropriate administrator at the school that was signed by both Chad and Tammy that effectively requested an increase of life insurance from the school provided $50,000 to add an additional $80,000 that was an optional coverage that Tammy would have to pay for. But that application, in fact, the state believes that if the court does rule that this evidence that would come in the form of Janice Olson's testimony, repeating what she had heard from Tammy, which includes a statement from Chad, that if the court rules that it is admissible, that it would be relevant on a number of grounds. One would be, it would be relevant on the insurance fraud charges, because it would simply show that Mr. Daybell, it would support the factual showing that Mr. Daybell, in fact, did up the insurance, then did go forward with a plan through a conspiracy, take Tammy's life, and then made the claim that insurance, and in fact, did receive a claim check for the full amount. If a jury were to find that, then clearly Mr. Daybell, under Idaho law, as cited in the brief, would be precluded from taking that benefit under what's called the Idaho Slayer statute. You cannot take someone's life and then financially benefit from that. So it's relevant to that point. It's also relative to the conspiracy to commit murder charges and the murder charges, in that it would tend to show an intent, motive, plan of Mr. Daybell and or his co-conspirators to take the life of Tammy Daybell. Your Honor, we understand in this context that Ms. Olson's testimony about what Tammy said her husband had said has two layers to it. The first layer would be Mr. Daybell's statement about wanting Tammy to up the insurance. That, we believe, would not come in under the hearsay, would not be prohibited by a hearsay objection, because under the rules of evidence, it would be a statement by a party opponent and specifically excluded from the definition of hearsay. So as we've laid out in the brief, we don't believe that there really is any basis for hearsay objection to exclude that statement on that element. Now, the second layer would, of course, be Tammy's relaying to Janice Olson that my husband said I wanted the insurance up. To the extent that is a statement from Tammy to Janice, we believe that under the Idaho Rules of Evidence 803(3), that would be admissible by this court as a statement that Tammy did in fact make as to her own mental and physical state. We believe that's true for a few different reasons. Effectively, we believe that when Tammy tells Janice, my husband wants me to up my insurance, she is in that same breath effectively indicating that that's not necessarily her wish, she is just communicating her husband wants the insurance. That, Your Honor, I think is reflective of Tammy's intention or lack of intention with respect to a desire to increase the insurance. To some extent, it likewise goes to Tammy's feeling of good health. I think generally there's a tendency for people to maybe increase life insurance if they feel like there's more likely to be a claim, if there could be a health issue. If someone is feeling healthy, they might be less likely to worry about increasing and taking on the cost for life insurance. So I do think there's some element and aspect of this that does show Tammy's self-perception as to her health. But it certainly goes, I believe, to distinguish her intent from Mr. Daybell's intent. And that is important because, Judge, we believe that in this case, and I have no doubt with the case overall, this court is familiar with State versus Abdullah, another Idaho death penalty conviction. Likewise, I suspect the court is also familiar with State versus Radabah, both cited in the brief. They both stand for the proposition that statements of a victim may be admitted for purposes to help explain, well, really for explanatory circumstances as to either a defendant and or the victim. And that can come in the state's case in chief. It can come as a response to a defense. If offered in the case in chief, that line of cases does indicate, specifically State versus Abdullah, that it could be relevant in a case in chief if, for instance, something is said even during law enforcement investigations or things come up in trial. So in other words, the state doesn't effectively have to wait until the defense puts on their case and then try to offer such evidence. If the state can reasonably foresee and successfully argue to the court that an issue that would trigger relevancy to the statement has been raised already, the state could put it in its case in chief. In this particular case, we've already heard evidence as this case has started that Ms. Daybell was on fluoxetine, which is a depressive drug, a drug to treat depression. And that's one issue that the state can offer to refute a potential defense that there could have been any inclination by Tammy to take her own life. Moreover, as the court knows from today's testimony and is well aware, there is a dispute as to whether or not Ms. Daybell died from natural causes. We've all known that from the beginning of this case. With respect to the statement about Mr. Daybell wanting to up his wife's life insurance coverage roughly a month before, in fact, she passed, that helps go to refute any argument the defense has and will continue to put on that Ms. Daybell died from natural causes, because it does show a motive, an intent, a plan for Mr. Daybell to take her life. It's a financial benefit, a financial motive behind it. Now, I think in the ordinary course of life, many couples, married or not, or partners, whomever might have life insurance needs to cover one another, it might be a normal part of financial planning to sit down and decide, do we increase the insurance this year? Do we need to do this? And so I think that's a plausible argument that the state needs to foresee and be able to meet with evidence. And I think that the statement from Chad that I want to, or we should increase your life insurance that was made to Tammy goes to help deal with that issue, to show it wasn't necessarily a normal financial planning issue of a couple. Tammy didn't say we should. She didn't say, you know, Chad said this, and I think I agree, and we ought to. She simply relayed, Chad wants my life insurance upped. That at least has evidentiary value to refute this idea. It was just a natural financial planning conversation that occurred between a couple, and not that type of a statement. But, Your Honor, that is something that should be left to the jury. That's something that a jury should decide what weight to attach to that statement. And arguably, there are reasonable inferences both ways. But we do believe very strongly that it's relevant enough that it should, in fact, be presented to a jury. We believe, as we've explained in the brief, that this evidence should overcome an IRA 403 objection If in fact the court does allow this evidence in, then there would be nothing improper under the State v. Floyd case, as noted in the brief, about letting a jury to decide whether or not there's guilt or innocence based upon a statement made by the defendant. And a statement that may well go to motive, may well go to intent, may well go to plan. That's not an improper basis for a jury verdict to be rendered. So really under 403, we believe that we will overcome any substantial prejudice argument. Your Honor, I've cited case law in the brief. Likewise, I think it's Michigan versus Bryant, a U.S. Supreme Court decision that addresses a potential confrontation clause objection. The test in that context is whether or not at the time the statement was made, let me back up, the analysis this court has to perform on that objection is whether or not that statement comes within the definition of testimonial evidence. The case as cited basically gives this court the factors to look at to determine that would be at the time the statement is made, was it intended to be used in any kind of legal or court proceeding? That's effectively what the test is that this court is called upon by the case law to look at. In this instance, we think that that's a clear no. This statement from Tammy to Janice, as made from Chad, was made roughly a month before Tammy even passed, long before charges were even brought. There's no indication at that point that Tammy would have any idea that any kind of criminal charges or proceedings would be initiated. And so frankly, we do believe under that test, there simply is no viable confrontation clause objection to be had against the evidence. Judge, I think that that is a nutshell overview. I'm happy to try to address any specific questions or inquiries the court may have, but I think that captures essentially what the state's argument is in this situation.
All right, thank you for the argument, Mr. Wixom. I do have the briefing. I don't have any specific questions for you at this time, so I will hear from the defense. I would note we did receive an objection from the defense filed on March 7th. Mr. Pryor, if you'd like to argue in opposition, you can do that.
And Judge, can I have permission to remain seated?
Yes.
Thank you, Your Honor, for that. Judge, this is one of the concerns that I have primarily. You know, we're talking about allegedly making a statement to his wife. And then allegedly Tammy Daybell taking that statement that she heard from her husband, relaying that to a third party, and that third party then getting in court and testifying about that statement. That's Judge, that's riddled with a lot of complications. And I don't agree with counsel saying that it's an exclusion to the hearsay rule. If you look at the present 803, I believe it was 8033 that counsel cited.
It was.
Judge, that has nothing to do with a statement about whether someone wants to get insurance or not. Has nothing to do with it. And as creative as Mr. Wixom would like to be in terms of suggesting that somehow that has anything to do with my current medical, emotional, or physical condition, it doesn't. Getting medical insurance or getting life insurance or whatever the case may be is an issue that deals really exclusively, it's a financial issue. Do we want to spend the money to do this? Do we want to invest in this? The other issue, Judge, is it's abundantly clear by the testimony from Officer Mattingly. The minimum was $50,000. And at the time they wanted to up the insurance, it was the first opportunity for them to be able to do that. And they chose in an inexpensive way to spend money to do that. But what this in essence is going to do is it's going to create a confrontation clause issue in a number of ways. But primarily the problem is also that what it's going to in essence do is it's going to require Mr. Daybell to have to respond to this because there's nobody else who can respond to this. And you're putting them in a position where the prejudicial impact of making that statement has to be balanced against Mr. Daybell's right, constitutional right to remain silent and not offer any testimony. By allowing this to come in, we're jeopardizing that right for Mr. Daybell. The other issue, Judge, is this, is that the prosecuting attorney has had this information, from what I understand, for 3 or 4 years. And as the trial is starting and as the trial is progressing, they file a motion in limine while the trial has already commenced. And if the court recalls that back on the close in time,
It was before the trial, but it was in March. It was March 4th.
Okay. But the difficulty, Judge, is this, is that at the last motion in limine that they brought, the court said you're getting tired, or at least you're growing weary of all of these motions in limine. They had ample time to bring this up. And the prejudice to counsel, defense counsel, is significant. Because how, the jury could easily read that and say, oh, the grand conspiracy. Mr. Daybell must have said that to Tammy. Tammy must have said that to this witness, and now this witness is going to testify about what she said. Judge, there's no way for me to defend that. There's no way for me to challenge that short of putting Mr. Daybell on the stand unless there was somebody else, and I haven't had sufficient time, nor will I have sufficient time to even investigate whether there were other people involved or other people who heard this. So again, Judge, aside from the hearsay issues, and it doesn't fall under 8033, Judge, aside from the confrontation issue, Judge, the prejudicial impact that it would have on this case and the bias that it would present greatly over states the significance of the value of this information. And I think that it would put Mr. Daybell in a very prejudicial place and force him to make decisions about how we're going to tactically proceed to address that. And I just think at that point, Judge, I think the court would be making a mistake by allowing the prosecutor to bring this forward and do that. And again, it's riddled with hearsay issues as well.
All right. Mr. Wixom, any rebuttal argument?
I believe very briefly, Judge. First, as to the argument that this is some kind of a last minute attempt or approach, the defense did point out that the state has had this for years. I'm sorry, the state has had this information for years, but so has the defense. This was disclosed back to the defense.
Mr. Wixom, and like putting somebody on notice of what statements that are, non-party statements or non-direct statements, it's the timing of putting them on notice in a motion in limine. I think that in fairness, just because it may have been disclosed somewhere, I do have some concern with the timing. I'll just address that.
And well, with respect to Your Honor, I understand that. I would simply just point back to the cases cited in the brief. I understand it's the court's discretion how it handles and treats motions in limine. I think in the case law, and certainly in my experience, motions in limine are often not brought until during trial. Often they're brought before trial, and I understand that. We do believe that we simply argue to the court that because of that disclosure, the defense shouldn't be caught off guard, respecting what the court just said, and I'll leave it at that. Your Honor, I do want to go back to Rule 8033. That exception does not just address physical, but perhaps that's all I raised. It also addresses emotional and mental state of the victim. And so a mental state such as an intention to increase or not increase insurance, or a statement about physical health. I don't necessarily need to increase the insurance. My husband wants this done. So I do think that 8033 does clearly apply. Judge, with respect to some of the other arguments as to what this does, the state is here today because we believe we have a lot of prejudicial evidence against the defendant. That's why the charges have been brought, and that's why we're spending the time in the trial. To argue that just because a piece of evidence is prejudicial, it should be excluded, well, Judge, that's the nature of a criminal proceeding. Now, we don't believe that it substantially outweighs the probative value. There are some cases cited in the brief, particularly with respect to things like graphic murder crime scene photos that the courts have repeatedly ruled that even though they are highly prejudicial to the defense, they are nonetheless admissible by the state for the purposes of meeting their high burden of proof beyond a reasonable doubt. And so the arguments that are being made by the defense in that regard really are weight questions. They're arguments that he can be making during closing argument. certainly he can also address this issue of suggesting that it forces the defendant to take the stand simply is not correct. The defense counsel certainly has the ability, and we've seen him perform so far in this case, to cross-examine witnesses, and he would be able to address this through cross-examination of Ms. Olson. So it doesn't force or back the defendant into having to take the stand to defend himself, but really, in addition to that, in any criminal proceeding, a defendant is effectively put in the place, or if they choose to meet any given piece of evidence, they may just have to make their own strategic decision whether they wish to waive the right to remain silent and defend themselves or not. And so I don't think it's an unfair argument to be made by the defense. I just don't think that they should succeed in that argument in this situation. This court can see from the record that this defense attorney is very aggressive with cross. He's very thorough. He's prepared. So I really think the state would argue to Your Honor that it simply isn't a viable argument to object upon. Under the Confrontation Clause, I've already cited that case law. I believe that the state, well, I'll rest on that issue and let the court make its decision, but that's all I have.
And Judge, Mr. Wixom brought up a couple things, and I just want to touch on one matter if the court gives me some leeway.
You may, go ahead.
And Judge, quite frankly, 404B is designed to give us notice and give us an opportunity to address these very issues. 404B does not apply to defense attorneys. It applies to the prosecution, and there's a reason for that. And the reason we're near the time for trial, and they bring up some obscure fact that says, by the way, we're going to use this, and we're not going to give defense counsel an opportunity to do that. So I don't know where the good cause is to show that they are able to get around this and then say, for 4 years we've had this information, and on the eve of trial we're bringing this forward. And on the last note, I appreciate Mr. Wixom saying that about me on national TV about my skills, but I don't necessarily agree with him completely, but it was very kind of him to say that.
All right, well, a couple of comments. First, I'm going to take the matter under advisement. I'll get an oral ruling for you tomorrow morning. 8:30 is the planned time to do that on this issue. I'll note that I don't think that 404B is implicated in this. However, under 403, the question the court looks at, it's been argued a lot of different ways here, but it's right in the rules, whether or not probative value is substantially outweighed by unfair prejudice. So not everything gets to be weighed by the jury if the court makes a balancing determination, even if it is admissible. And if the court determines that probative value would be substantially outweighed by unfair prejudice. So I am going to take that one under advisement. In terms of the next motion, counsel, I'd like to hear argument on that. I don't want to reiterate or go back into 403 balancing other matters we just argued on the first motion to the extent they apply to the second motion, but it has its own unique issue and a separate brief filed by the state, and the timing as well is different. So this is the March 14th motion, second motion in limine in relation to a state's seeking introduction of a statement by a witness, Janet Anderson, quote, "She is a zombie," as it relates to Tammy Daybell. With that, Mr. Wixom, if you'd like to present argument on that motion. And I will note on that motion, I believe the motion referenced exhibits that I don't think were ever received by the court. And I'll look, if they're not in by now, I'm finding them untimely and won't consider. If this is the motion I'm thinking of, did not have attached exhibits, but otherwise I understand the content and context of the motion, so you can argue it.
Thank you, Your Honor. And I think I can be more brief. I don't have any desire to be redundant, but I would first note to the court, this is actually a two-part motion. There are two witnesses with two statements. The court has accurately reflected that we're seeking an order allowing us to introduce testimony from Janet Anderson, a school secretary, who indicated that she heard a conversation between Tammy and another coworker where Tammy indicated that her husband said she is a zombie, and that Tammy, after that, said, "I'm not a zombie," and appeared to be laughing that off and walking it away. And that was relatively close time to the time of Tammy's death. The second statement, to be clear, is a statement from a witness, Pam Peebles, who is a school teacher at the school, who was interviewed back in May 2020. And she did give a statement. She's what we'll call a health witness. We have anticipated calling her in preparation for testimony just a couple of months ago, relative in time to that we filed the motion. She actually, on her own fruition, made an additional statement where she says that Tammy told her that this is the best I have ever felt in my life, and she was excited about getting ready for a race. Now, she indicates that that was told to her by Tammy on the Thursday before Tammy passed the following Saturday, 2 days later. Judge, we believe that those statements are both admissible. We do understand the timing issue, but in this situation, we're not sure the state could have provided them in a more timely manner. We did provide them before trial. Those two pieces of information both came up in trial prep in roughly early March. Rather than going through all the applicable rules, I would just make one quick argument. While certainly I understand the objection the state or the defense may make as to the timeliness and ability to respond, in these situations, I don't think the defense or frankly the state in other situations are left in any different position than if any given witness says something brand new on the stand during a trial, which we've all seen happen many times, that no one had ever heard before. They would be left in that position where they would simply have to respond on the fly. They don't have to do that here. And in this case, very close in time after these were disclosed, relayed to the state, they were disclosed to the defense, albeit a few weeks before trial, but at least the defense has had the benefit and no less benefit than the defendant or the state did to respond and figure out how to handle this evidence. And so I'll just leave my argument at that. We do believe that both of those pieces of evidence should be admitted to trial.
All right, thank you, Mr. Wixom, and I will note I'll incorporate, of course, in any decision, the briefing that was supplied as well. Mr. Pryor, as to the second motion in limine on the proposed introduction of statements, quote, "She is a zombie" from Janet Anderson, and then Pam Peebles, the health witness, statements, "This is the best I've ever felt in my life," or "excited about getting ready for a race." You can pose any objection you have at this time.
Judge, one of the concerns I have is that these disclosures took place while Mr. Wixom was interviewing these witnesses for their trial prep. Now, that could be addressed potentially in cross-examination, but the difficulty is, again, the appearance, Judge, the appearance that Mr. Wixom is talking to witnesses and doing this, and suddenly they make these disclosures. The first one with, I think it was Janet Anderson, heard a conversation. That's problematic on a number of levels, Judge, and it's problematic that she heard a conversation and she's going to relay a conversation that she heard. That in itself brings up another of evidentiary rules, and then I'll let the court do the analysis as far as hearsay analysis on that. The other one, talking about the other witness, Judge, again, the timing is problematic. And I understand that things happen and people bring up information at the last minute. Those things do happen. But this seems to be a little convenient that suddenly we're bringing up information from the very first motion in limine. Now we have two more additional statements. The only difference, Judge, is these statements, they came about as a result of preparation for trial. And they happen to be witnesses who are on the very side, at least from my perspective, of, on the opposite side of the case. And ironically, I'm not seeing any disclosures that seem to favor the defense or go that direction. And again, I'm not going to reiterate all of the stuff about relevancy, Judge, but the reality of this is that the timing is suspect, and giving me sufficient notice to address these, it's just not there. And again, the prejudicial impact greatly outweighs the probative value.
All right. Well, counsel, they're both under advisement. Take a look through them later today in the morning. I'll prepare a ruling on both so the parties have the benefit of knowing whether or not that information is entitled to be admitted at trial. I do appreciate the sides briefing and arguing it and bringing it forth in a motion in limine. As they say, better late than never, and certainly I'd rather be considering this when I have time to have this instead of it spontaneously coming up on the stand with a witness. So we will conclude for today then with those under advisement, and I'll intend to have an oral ruling on both motions tomorrow morning at 8:30. We'll then have the jurors in at 9 for further evidence. So we'll be in recess.
Thank you, Your Honor.
Thank you.
Okay, so that concludes that and clarifies the start time. So since that's on the record, we should be able to view that. So jury is due to come at 9, so there may be a little bit of time between when they address the issues and when the jury arrives. So we'll plan accordingly, and see you in the morning. Until then, have a great evening. See you tomorrow. Bye-bye.